Good evening, ladies and gentlemen. It's a great honor to be invited to speak on this special event. Here, I want to talk about unilateral sanctions and the anti-sanction law of China. On June 21st, the Uyghur Forced Labor Prevention Act took effect. This act was signed into law by President Biden last year. The act established a rebuttable presumption that any goods, wares, articles, and merchandise mined, produced, or manufactured wholly or in part in the Xinjiang region of China or by entities on the UFLPA entity list are presumed to be made with forced labor and thus prohibited from entry into America, except the importers can provide a clear and convincing evidence to prove their goods are not made with forced labor. This act is another example of U.S. government imposing economic sanctions unilaterally upon Chinese business and individuals. It's not the first time. Actually, before this act, U.S. government has already imposed many sanctions against Chinese entities and individuals, especially during China-America trade war. The grounds that the U.S. government invoked to impose sanctions include national security, counterterrorism, proliferation of massive destructive weapons, drug trafficking, and human rights. Among these grounds, violation of human rights such as forced labor, genocide is often cited in practice. This act is a typical example for U.S. to use human rights violation as a pretext to impose sanctions. This act is targeted directly at China. What is worse is that the act based sanctions on a presumption of a guilt other than presumption of innocence. That is to say, all goods made in or in connection with Xinjiang are presumed to be made with forced labor. This presumption is arbitrary, discriminatory, and malicious. It shifts the burden of proof from American government to foreign entities. The importers must prove that they are innocent, otherwise they are guilty. What is more unacceptable is that this act is completely based on concocted facts that there exists genocide and forced labor in Xinjiang. This accusation is an entire lie. Did the lawmaker of the act witness the forced labor or genocide with their own eyes in Xinjiang, or have preponderant evidence to prove them? The answer is no. Then how dare they can come to this conclusion? From this, we can see these lawmakers are biased, prejudiced against China. The fact is that, as I know and see by myself, Uyghurs are living a better life, and the number of Uyghur population is increasing greatly since 1949. So in this sense, sanctions imposed by U.S. government in accordance with an act based on a lie will not accomplish a so-called noble goal of eliminating forced labor. On the contrary, prohibition of goods of Xinjiang will only hurt Uyghurs' welfare. Even worse, owing to sanctions, many businesses will probably be forced to close down, and Uyghur workers will lose their jobs and sources of income. They will fall to poverty again. Even for American business and people, the sanctions will not produce any benefit, and the sanctions will destroy the global supply chain as well, which is no good for the world economy. In addition, I want to suggest that this kind of unilateral sanction by U.S. violates international law. And the international law, only multilateral sanctions authorized by UN Security Council are legal. We can find the justifications in UN Charter. Article 39 and 41 are key provisions governing the sanctions by the UN Security Council. For example, and Article 41, the Security Council can authorize member states to take coercive measures not involving the use of armed force to punish target country. Since 1945, the UN has already authorized sanctions upon certain countries. For example, South Africa because of apartheid, Iran, North Korea, etc. These sanctions imposed by UN cause less disagreement in international community. However, with regard to unilateral sanctions, there have been a lot of controversies over the legality of these sanctions. In particular, these unilateral sanctions have been opposed firmly and consistently by developing countries. Developing countries have contended that unilateral sanctions should be eliminated as it infringes upon their right to economic and social development. The UN General Assembly has also passed a resolution which calls upon all states not to recognize unilateral extraterritorial coercive economic measures or legislative acts imposed by any state. The Asian African Legal Consultative Organization has also suggested that unilateral coercive economic measures constitute extraterritorial sanctions and therefore violate international law. Lastly, I want to talk about how to deal with unilateral sanctions. As you know, Chinese business and individuals have been victims of unilateral sanctions imposed by US. So, for Chinese government, how to make an effective response to the sanctions is a big challenge. Fortunately, Chinese government has already recognized and found a way to deal with these sanctions. The way is to legislate, to establish an anti-foreign sanctions law framework. As of now, the framework of anti-sanctions law of China has come into being. The framework consists of three legal instruments: the Unreliable Entity List Act, the Blocking Statute, and the so-named Anti-Foreign Sanctions Law. The Unreliable Entity List Act is made and administered by Commerce Department of China. And this act, any foreign entity which violates rules of market transaction, disrupting dealings with Chinese business organizations or individuals, or exercising discrimination against them, will be put on the unreliable entity list and will be imposed retaliatory sanctions. The sanctions include prohibition or restriction of dealings with Chinese business, investment in China, entry into China, denial of work permit or stay in China, and fines. The blocking statute is also promulgated and administered by Commerce Department. And the blocking statute, when each agency and committee affirms improper extraterritoriality of foreign laws, the Commerce Department can issue an order not to recognize, enforce, or abide by the foreign law or measures. The blocking statute also provides for relief to victims whose legal interests are hurt as a result of abiding by foreign law. Chinese victims who suffer loss can file a lawsuit claiming damages against beneficiaries who benefit from the judgment or arbitrary award rendered in accordance with the foreign law. The so-named anti-foreign sanctions law provides the most important legal basis for taking countermeasures against foreign sanctions. This law is promulgated by the Standing Committee of People's Congress, the lawmaking body of China. The purpose of this law are to safeguard China's sovereignty, national security, and development interests, and to protect the legal interests of Chinese citizens and organizations. And this law, when foreign country, in violation of international law and the norms of jurisdiction, contains, suppress, bullies China, or exercise discrimination against Chinese citizens or organizations, or interfere with the internal affairs of China, China is entitled to take corresponding countermeasures. These countermeasures target those individuals and organizations engaged in directly or indirectly in making, deciding, or implementing the above-mentioned discriminatory measures. And the countermeasures will also be extended to their families and organizations they are affiliated with. The countermeasures include denial of visa, refusal of entry into China, or deportation from China, freezing or detaining assets, prohibition of dealings with Chinese organizations or individuals. After anti-sanction law took effect, China has imposed dozens of sanctions upon foreign individuals, organizations, including the U.S. former Secretary of State, Pompeo, National Advisor Biden, American military enterprise, Lockheed Martin, etc. Okay, this is what I share today. Thanks.